Hi, so today we're actually going to do and talk about the top 5 things that clients or people going through asset division or separation have. And hopefully this will answer a few of those questions that maybe are coming up for you, but you don't actually have an answer for them right now. So the first one in asset division is, am I entitled to 50% of the asset pool? And the answer to that is no, not necessarily. There is no automatic right or of a 50-50 division of assets and debts in a relationship. That's a fallacy. It may work out that way, absolutely, but you can't assume that that is the case. So it's really important that you actually find out exactly what you're entitled to in order to assess exactly how much you should be going for and what is reasonable and within your range. So that's the first question. So stemming on from that one is the second question is, well, if I'm not entitled to 50%, Tracey, what am I actually entitled to? Well, and the truth is I can't answer that for you over this conversation. I would actually have to go through and look at all of your assets. And what we do, though, is I'll explain the process for you. There is a 4-step process under the Family Law Act that every judge and every lawyer is required to actually go through to assess what your entitlements are. So the first step is working out what your property pool is. And that is all of your assets added up, regardless of whose name it is in, and all of your debts are then taken away, including your super. Okay, so we add all your assets, including super, take away all your debts. And then from there, you're left over with what we call a net amount of property, and that's your net property pool. That is the figure that's actually up for division between the two of you. So from there, we've then got to work out what you're entitled to. So we've got to assess your financial contributions to a relationship versus your non-financial. Financial contributions are anything you've ever earned in the relationship, anything you brought into the relationship, and any gifts or inheritances you may have received. That is then weighed up against non-financial contributions, which are such things like raising children, doing all the cooking and cleaning, doing the books for a business, doing renovations or landscaping, mowing, all of that stuff. Things that actually haven't produced a financial contribution in some way, but have still contributed to the matrimonial relationship. So from there, what we do is we look overall and we don't do a specific calculation, but we weigh them up in a general basis, and then we assess your contributions on that portion. So from there, you think, okay, well, that's what I'm entitled to, except we move on to step number 3. And step number 3 is then considering what your future needs are. And those are such things as who's got the care of the children, majority care of the children, if there's any health issues, if there's any disparity in income, or any money or financial resources overseas, or money being received as part of a trust. Those types of things. So what we do is we actually make an adjustment for future needs if it's required, and that will adjust out what those contributions were. Then we do step 4 is having a look at those final adjustments. The courts step back and look at it holistically and say, is this really in the best interest of all the parties? So is this fair and equitable? So if it's not, what they do is they go, well, let's just tweak that up in a roundabout way. So from there, they then get a percentage, and that's what you're actually entitled to of the net property pool. So I hope that gives you some clarity. It's not something I can do here, but honestly, I would highly recommend if you ever seek legal advice for anything, it is to work out exactly what your range is entitled to so that you can actually then go and start negotiations with the other party. Don't negotiate until you know, because you may end up cutting your nose off to spite your face and literally leaving a lot of money on the table, or you might assume that you're entitled to more than you actually were. So make sure that you find that out. So then we have number 3, the next question that people ask is, do I have to include all of my assets? What if they don't know that I've got an asset? Do I have to tell them? And I actually get this a lot. And like, for instance, the cash under the bed scenario. And the answer is yes, you do. And here's why you do. If you go through and you get a formal arrangement or a formal order and you've divided all your assets, and then the other party finds out later on that you've actually withheld assets, significant assets, out of the actual division of property, then you actually run the risk that that whole matter will be reopened. They will go through and redivide up the property, and your property might have increased in value by then. Plus, you will end up with legal costs against you to punish you for not doing the right thing. So I highly recommend you disclose everything you possibly can to make sure there is nothing left on the table, so that you can actually finalise it once and for all. Because that's the whole point of it, isn't it? You want to finalise it. You don't want to leave something there loose so it can be reopened. You have to go through all this saga all over again. So make sure you put all your assets in. Now, the other question we get is, it's more of a statement usually, and that is, the asset's actually in the other party's name, so I'm not entitled to it, am I? And the answer is, yes, you are. The assets that are included and the debts that are included in the property pool are everything regardless of whose name it's in. So, houses, cars, furniture, cash, jewellery, superannuation, all included, including credit cards, lines of credit, personal loans, tax loans, business loans, a business, all of that comes in. It doesn't matter if it's in your name, doesn't matter if it's in their name, it all comes into the pot and you're still entitled to it. As for what you're entitled to, depends, but at least you know it's all there, including inheritances. So make sure you actually factor everything in that you can. Even if you don't want to deal with it, you still need to include it. Okay, it's really important. Otherwise, again, the court can overturn the agreement. The final question that everyone asks is, do I have to go to court to deal with this? And the answer is no. No, in fact, most people resolve it all amicably out of the court. So you do that by either entering into a consent order or what we call a binding financial agreement. It's a matter for you as to which way you go, but I do recommend that whichever way you go, make sure that you are finalising it in a formal basis. Because if you do a gentleman's agreement between yourselves and you say, let's just divide it up, we don't need lawyers, then at any time in the future, somebody can come back and say, hey, I now want more money, and you've actually opened that up. So you want to lock it down, make sure that you've formalised and finalised all of your property matters with the other party by getting it in formal documentation. So I hope that helps, and I hope that's giving you some clarity and some certainty about some of the questions that you're being asking yourself. If not, if there are more questions, then just reach out and ask us, and we'll be able to answer those for you pretty quickly. Otherwise, I hope you have a very smooth and amicable property settlement. See you later.